Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to do a deep dive into verdicts and settlements for traumatic brain injury, the most recent verdicts in New York. So we go with the first case, and this is a case that was decided in October of 2023, so just a few short weeks ago, and it was a plaintiff's verdict. The case was in Suffolk County, which is in Long Island, and it's known as a conservative venue. And what happened was, it happened back in February 14th of 2019, and the case was filed about a month later in March of 2019, and the trial didn't happen until 2023. So it happened about, I would say, like 4 years later, 4 years later. So what happened in this case was the plaintiff was a 53-year-old laborer, and he fell 14 feet from an extension ladder to the floor at a work site that was owned and managed by the defendants, and they were like a village LLC and also a company. So the plaintiff was doing spackling work when he fell, hitting his head, and his injuries included loss of consciousness, a concussion, post-concussion syndrome, a traumatic brain injury that was associated with a contusion and a subdural hematoma and a subarachnoid hemorrhage and a non-displaced fracture of the posterior parietal bone. So he had some really serious injuries to his head, and he underwent an anterior cervical discectomy and arthrodesis fusion as well at C67 with an insertion of an intervertebral implant. So the plaintiff argued that the defendants were negligent in violating the labor law, which is section 200, the common law, as well as section 240, which is the strict liability of falling from a ladder, and the industrial code, which is 241.6 and title 23. And the defendants argued that the accident wasn't because of a failure or defect in the ladder, but it was the manner in which the plaintiff was using the ladder. He was using it unsafely, that he was attempting to spackle while standing on the fourth rung from the top, while the ladder's feet rested on debris on the floor. And the plaintiff moved for summary judgment on the issue of Labor Law 240, and that motion was granted. So what was the result? The result in this case after the trial was a compensatory pain and suffering amount of $1,065,000. So that was, I would say, a relatively, modest amount for these kinds of injuries, considering it was a fusion and a TBI, but you also have to consider the location. It was Suffolk County, which is a very conservative, low-value venue. And it was a verdict. So that was a jury verdict. Okay, let's go to the next case. The next case was decided on September 28th, 2023. And the case was filed on April 6th of 2017. That was the date of the incident when the injury happened, but the filing was not until November 27th, 2017. But in either case, it was about 6 years to get to trial. And this was a little bit of a different case. This was a medical malpractice case. What happened was the mother of an infant plaintiff was at a hospital for the baby's delivery by the defendant doctor. And one of the defendants was the Westchester Medical Group. And so what happened was the infant reportedly suffered a traumatic brain injury, a seizure disorder, and other injuries, including cognitive and neurological deficits, because of the way that the doctor who was delivering the baby used a vacuum extractor. And so the plaintiff asserted medical malpractice, arguing that the use of the vacuum extractor caused the brain injury. There was a negligent delay in recognizing the signs of fetal distress, and that the defendant doctor should have offered to perform a cesarean section. The plaintiff also argued that there was no informed consent for the vacuum extraction because the doctor never advised the mother of the risks associated with these vacuum extractors. And the defendants argued that the fetal heart tracings were properly monitored, and when an atypical fetal heart tracing was observed, the doctor discussed using a vacuum to facilitate delivery and obtained the mother's verbal rather than written consent given the urgency of the situation. And they also argued that vacuum was applied twice. The defendants argued that the plaintiff was discharged 3 days later and that his discharge examination was normal. And they asserted that the plaintiff was later diagnosed with an idiopathic seizure disorder and idiopathic infantile spasms. So the defendants were basically saying, like, look, this happened, the vacuum was applied twice, there was no issue with the vacuum, we examined the baby was fine, he was discharged home, and then later, months later, he had some kind of seizure disorder that was unrelated to anything that happened in the hospital. And the defendants denied the plaintiff's claimed injuries were caused by the labor and delivery. So this case went to trial as well, and there was a verdict, and this was Westchester County, which is a fairly conservative venue, and the verdict was actually a defense verdict. It doesn't say here exactly on which issue, whether it was on the issue of causation or the issue of negligence or rather medical malpractice, departure from good and accepted medical care, but it was a defense verdict, so the plaintiff received nothing. Okay, let's go to the next case. The next case is Thompson versus County. This is a case actually out of Nassau County, which is also Long Island. The trial in this case was July 28th of 2023. Okay, so this past summer, but the date of incident was November 26th of 2014. Wow, so it's about what, 9 years to get to trial in this case. That's a really long one. And the date of filing was November of 2015. So they filed the lawsuit about a year after the incident happened. So I'd say 8 years from the filing of the lawsuit to get all the way to trial, which is a little bit strange because Nassau County is known as a fairly quick county that tends to move their cases. So in this case, the plaintiff was a 40-year-old woman, and she parked her car in the lot of a hospital where she worked, and she was walking toward the building using an unmarked crosswalk in the roadway when she was struck from behind by a police vehicle driven by the defendant, who was an employee of the County of Nassau and the police department. So the plaintiff claimed that she suffered a traumatic brain injury as well as injuries to her left knee and lumbar spine, the lower back. And the plaintiff asserted negligence. The defendants disputed the nature and extent of the plaintiff's injuries and argued that she was negligent. And at trial, jurors determined that the plaintiff was 20% negligent, but that the defendant was 80% negligent. And after that, the case ended up settling, and it settled for $1,600,000. So I think that's a pretty good settlement for Nassau County. So that was the third case. Here's another case, also from Nassau County. This one, the date of incident was October 5th of 2016, and the trial happened in May of 2023. And this one was a plaintiff who was 60 years old, and he experienced vehicle trouble while driving and pulled over to the shoulder of the Long Island Expressway. He exited his vehicle and was standing in front of it attempting a repair when his car was struck in the rear by another vehicle driven by the defendant, an individual. And so the plaintiff claimed to suffer spinal stenosis at L3 to L5, requiring a lumbar decompression surgery, lumbar disc replacement, lumbar radiculopathy, that's the radiating pain from the lower back traveling to the legs, myalgia, disc herniations at L3 to L5, a bulging disc at L5S1, and a traumatic brain injury. It doesn't give any details about the traumatic brain injury, just that he's asserting it. But it said that the plaintiff asserted negligence in failing to keep a proper lookout and failing to observe the plaintiff's vehicle on the roadway. and the trial proceeded on the issue of liability only. And the verdict was actually a defense verdict, so the plaintiff got nothing. I guess they figured that the plaintiff, or for whatever reason, the defendant was not at fault. Okay, let's go to the next case. Here's a case from March of 2023, and this date of incident was June of 2012, and the case went to trial in March of 2023. So these cases are taking quite some time. This is also a medical malpractice type case. Here what happened was plaintiff was diagnosed with certain conditions like hydrocephalus, global development delays, and he had a surgery when he was 7 months old at the defendant's medical center. And the plaintiff reportedly received pediatric care from the defendant doctor. And so the plaintiff alleged brain injury due to the surgery. The plaintiff argued that the defendants rendered negligent care, and the parties ended up agreeing to a settlement. This was a case in the Bronx, and the settlement was that the defendant doctor paid $130,000, and the medical center where it happened paid 1.17, so $1,170,000. So the total settlement was $1.3 million. Okay, let's go to the next case. Here's an interesting case. This case, the date of trial was December of 2022, and it happened in Queens. The lawsuit was filed in 2020, so about 2 years, because the index number is from 2020. It doesn't say exactly when the date of incident was in this one, and it was also a malpractice case involving a brain injury. This was a severe brain injury. So what happened here was a woman who was pregnant and due to deliver in about 2 weeks fell on her abdomen and went to a hospital and was seen by a defendant doctor. And she was placed on an external fetal monitor and discharged. And then she saw another doctor, and on 2 occasions there was no workup done for a placental abruption. And so she gave birth to the infant via a cesarean section performed by a third doctor, a different doctor. And during the delivery, a placental abruption was confirmed. So the plaintiff then reportedly suffered anemia, hypoxic ischemic encephalopathy, and was left with brain injuries. And there was no independent functional movement and cortical vision impairment. So the plaintiff argued that the placental abruption was not timely and properly treated, and that the doctors departed from accepted medical practice by sending her home after the first visit and by not performing the fetal heart monitoring during her second visit. And they also departed from accepted medical practice by not performing the cesarean section earlier and by discharging her from the hospital. So a jury argued that one of the doctors did depart from accepted medical practice in failing to perform the fetal heart monitoring, and awarded the plaintiff $3,736 for annual medical expenses for 20 years, $42,261 for the annual cost of medication. It gets specific as to the amounts, but the overall verdict in this case was actually very high. It was $35,182,818. So yeah, it sounds like it was a very serious, very serious injury. So Okay, let's see what other cases we have here. Here's a case, this is in Ulster County, which is a little bit upstate. This was, the trial was November 29th of 2022, and the date of incident was November 15th of 2021. So this was a quick one from the date of incident to the trial, only about a year. And what happened here was the plaintiff was a 16-year-old and he was driving, and a second driver was driving the opposite direction, and then a third vehicle pulled over in the lane in front of a police vehicle with its emergency lights activated. So the other driver, the plaintiff was driving north and the other driver was driving south. So the southbound driver reportedly attempted to pass the police vehicle by crossing the double yellow line, and in doing so, that driver struck the plaintiff's vehicle head on. And the plaintiff suffered injuries that included a traumatic brain injury with loss of consciousness, an acute avulsion of the right sartorius and tensor fascia lata, TFL, tendons, a myofascial tear, closed degloving injury of the right lateral hip. Oh, that's pretty serious. Edema, fluid along the left iliopsoas tendon. Oh, wow, this is really serious injuries. Avulsion at the origins of the right sartorius and TFL tendons along the anterior superior iliac spine and iliac crest, and ecchymosis to the left hip with numbness and tingling. So real serious injuries, and the plaintiff argued that the defendant was responsible for paying the plaintiff's damages. And during trial, this was a settlement, and the settlement was for $75,000. I'm thinking that probably it was 100 policy, and for whatever reason, they didn't get the full 100. I'm not sure why, but yeah, that's, considering those injuries, you would think that it would be worth more, but maybe it was probably a limited policy. I'm just guessing that. Okay, let's see what other cases. I want to find some cases. It seems like a lot of the cases, for whatever reason, are upstate or out in Long Island. I want to find a few cases in the city to see how the city cases are going. But yeah, I'm not seeing too many city cases in this particular database. I'll try a few other databases in the future just to give different, because different companies report different cases. So like I might find some cases in this database. There's like Lexis, there's Westlaw, there's ALM. So there's different databases. There's the jury verdict reporter, so they might have different information. Here's a case from Queens. This is a case in Queens from 2021, and the date of incident was 2017, and it was filed in 2018. And this case, this was a lady who was 51, and she had mild traumatic brain injury, post-concussion syndrome, headaches, difficulties with speech, memory, concentration, herniated discs at C67, and she had decompression surgery. And she was struck on the head by a piece of ice that fell from an awning as she was lawfully walking by a building owned by the defendant. And she argued that the defendant was negligent in allowing the accumulation of ice without inspecting or maintaining the presence of the ice, and the defendant denied, arguing that the injuries were degenerative in nature, so not from the ice falling on her and hitting her in the head, but rather just from living her life before. And it was a bifurcated trial, so the jury found in favor of the plaintiff on the issue of liability. So they found the defendant negligent, but then they allowed for $100,000 in damages. And prior to the trial, the parties entered into a high-low agreement of $500,000 high. That means no matter what she got, right, if they would have given her like, I don't know, $5 million, she still would have gotten only $500,000. That was the high. And the low was $75,000. So if the jury would have said, you know what, this isn't worth anything, we're going to give you like 1 penny, or we're going to give you 0, she still would have gotten the low, which is the $75,000. So the high-low just kind of like sets the high and the low, the parameters for the trial. It gives you some protection, but it also doesn't allow you to get a high amount because of it has a ceiling. So in this case, since it was 100,000, it was in the middle, so she just gets the 100,000 because it wasn't, it was within the parameters. Okay, I hope this was helpful. I'm going to do a few more videos where I talk about a few other cases, but this was the recent cases in this one particular database about traumatic brain injury. Let us know what questions you have. Please like and subscribe to our channel. Feel free to comment, and I respond to the comments, as well as do last week tonight videos where I answer the comments. And in addition to that, I'm doing last week tonight live, where you can join live and ask your comments and have a conversation, and we try to answer your questions and give you some consultations and feedback live. Okay, everyone, have a great day. Thank you so much. Bye-bye.